Hello, my name is Nathan Dorn. I'm the curator of the Rare Books collection of the Law Library of Congress. In this video, I'd like to talk about a recent addition to the Law Library's Rare Books collection. This is a document that was signed by President Andrew Johnson in preparation to issue a proclamation about the ratification of the 14th Amendment. The 14th Amendment granted citizenship to all persons born or naturalized in the United States, a provision that extended citizenship to formerly enslaved people. It also made it so the right to due process of law and equal protection of the law would, going forward, apply both to federal and state governments. Today, the process of administering the ratification of constitutional amendments is the responsibility of the head of the National Archives and Records Administration, that is, the Archivist of the United States, with the assistance of the Director of the Federal Register. But prior to the creation of the National Archives, these responsibilities fell largely to the Secretary of State. The Secretary of State was the recipient and custodian of all federal legislation, beginning with the Records Act of 1789. The Records Act also handed over to the Secretary of State responsibilities that were formerly held by the Secretary of Congress. An important example of these is the role of Keeper of the Seal of the United States. In the past, many more documents received the seal of the United States than do today. Beginning in 1789, sea letters and ships' passports, including Mediterranean passes for instance, received the seal. So did letters of marque and reprisal, documents related to public debt, patents for lands or for inventions, presidential pardons, certain extradition warrants, full powers for treaty negotiation, exequaturs, and ceremonial letters. And important for this document, presidential proclamations also received the seal from 1789 to 1967. Section 4 of the Records Act says that it's forbidden to affix the seal to any of these documents without the special warrant of the president therefor. People have usually interpreted this last phrase to mean that the president must issue a written warrant if he wishes to authorize the Secretary of State to place the seal on a document bearing his signature. Placing the seal on a presidential proclamation, then, required the president to issue a written warrant to authorize the seal's use. This document is an example of just this sort of written warrant authorizing the Secretary of State to affix the seal. In it, Andrew Johnson requests the Secretary of State to place a seal on a proclamation that two states, North Carolina and Florida, have ratified the 14th Amendment. It's interesting to remember that President Andrew Johnson, who signed this warrant on July 11, 1868, opposed the 14th Amendment. Despite his involvement in what he called ministerial roles related to its ratification, he made it clear that these did not commit the executive to an approval or recommendation of the amendment to the state legislatures or to the people. These included, among several others, a bill to extend the provisions of the Freedmen's Bureau Act of 1865, versions of which Johnson vetoed twice, the Civil Rights Act of 1866, and the Reconstruction Act of 1867. In these three instances, Congress overturned Johnson's veto. As a reminder, Rare Book service is available at the Law Library on weekdays by appointment. We hope to hear from you. Thank you.